Call this meeting to order. It's the Standing Committee on Justice and Human Rights. It's meeting number 71. We are televised today, and pursuant to the order of reference of Friday, November 28th, 2014, we're going to be dealing with Bill C-35, an act to amend the Criminal Code, the Law Enforcement Animals, Military Animals, and Service Animals legislation. Today, we are fortunate to have the Honourable Peter MacKay, the Minister of Justice and Attorney General, to lead us off for the first hour on the discussion on this particular bill. Mr. MacKay, the floor is yours.
Merci, Monsieur le Président, chers collègues. Je suis toujours...
Thank you, Mr. Chair, and dear colleagues. I'm always pleased to appear before you to speak to this bill, which deals with service animals.
Here, as you know, to discuss yet another piece of criminal justice legislation that the government believes will contribute to making Canadian communities safer. I thank you in advance for this committee's hard work and commitment to do a thorough and rigorous review of important bills, both government and private members. I hope that my remarks today will assist you somewhat in the review of Bill C-35, the Justice for Animals in Service Act bill, referred to colloquially as Quantos Law. Now, Quantos, I suggest many of you will know, was an Edmonton police dog that was fatally stabbed October 7, 2013, while assisting police in apprehending a suspect. The tragic killing of this beautiful law enforcement animal struck a chord with a lot of Canadians, and many in the police, legal, and community groups called for greater recognition and protection of service animals. Bill C-35 fulfills a 2013 Speech from the Throne commitment to enact a law such as this in recognition of the daily risks undertaken by animals used by police to assist them in enforcing the law and protecting society. Quanto's killing was also the most recent instance in which a police service animal was killed in the course of a police operation, and there are other examples that I'm sure you will be studying. En plus de proposer la création d'une nouvelle...
In addition to proposing a new criminal code offense that would specifically prohibit the killing or wounding of a law enforcement animal, Bill C-35 would also extend specific protection to trained service animals that assist persons with disabilities, as well as military animals that assist the Canadian Forces in carrying out their duties.
The person who killed Quanto was subsequently convicted under an existing section of the Criminal Code, Section 445, for the willful killing of a dog, along with other offences that were arising out of the same set of events on October 7, 2013. The criminal responsible was sentenced as a result to a total of 26 months in prison on various charges, of which the sentencing judge attached 18 months specifically for the killing of Quanto. The court also banned him from owning a pet for 25 years and banned him for driving for 5 years. This sentence, and in sentencing the offender, the judge stated that the attack on this dog was not just an attack on a dog, it was an attack on our society and what is meaningful to our society, close quote. The government agrees wholeheartedly with this sentiment and believes that the creation of a specific criminal code offence coupled with specially tailored sentencing regime would contribute to the denunciation, both general and specific, as well as deterrence of such crimes. And these are well-known sentencing principles, I know, for this committee. J'aimerais prendre un moment pour passer.
I would like to take a moment to review with you just what Bill C-35 proposes in terms of amendments to the Criminal Code.
The bill would clearly define which animals would fall within its ambit. Secondly, the legislation sets out the element of the new offence. The prescribed conduct is the killing, maiming, wounding, poisoning, or injuring of a law enforcement animal while it is aiding a law enforcement officer in carrying out the officer's duty, and a military animal while it is aiding a member of the Canadian Armed Forces in carrying out that member's duties, or a service animal performing its tasks. The necessary mental element is willful and without lawful excuse, a common standard used in the Criminal Code, in order that accidental or negligent conduct would not be criminalized by this new offence. So, obviously, a great deal of discretion within the courts for findings of fact based on evidence. Finally, thirdly, similar to the existing Section 445 of the Code, injuring or endangering other animals, the new offence would be subject to a maximum penalty of 5 years imprisonment when prosecuted on indictment, and 18 months imprisonment or a $10,000 fine for summary conviction. So there's a hybrid element to the offence. It is the sentencing regime that distinguishes this new offence from Section 445, and it does so by introducing a provision, Section 718.03, which expressly directs a sentencing court to give primary consideration to denunciation and deterrence as sentencing objectives in respect of this new offence. This provision will apply whether the animal in question is a law enforcement animal, military, or service animal. However, with regard to an offence committed against a law enforcement animal, Bill C-35 would require the sentence imposed for the offence to be served consecutively to any other sentence imposed on the offender for an offence committed at the same time. And as is the case where a law enforcement animal is killed while assisting a law enforcement officer in carrying out his duties, or I should say, and the offence is prosecuted by way of indictment, so there is a selection here, the offender would be liable to a mandatory minimum penalty of 6 months. This joins the some 60 other mandatory minimum penalties already found in the Criminal Code. During second reading of this bill, I was pleased to note that there was broad support across party lines. I see this as one of the more nonpartisan issues and nonpartisan legislation that may come before this committee. And in fact, there is a great deal of support for the enactment of the provisions in the Criminal Code that deal with the intentional injuring and killing of law enforcement animals, military animals, or service animals. At the same time, I acknowledge that there will no doubt be questions raised with regard to the proposed mandatory minimum penalties where a law enforcement animal is killed while assisting a law enforcement officer engaged in enforcing the law and prosecuted by indictment. I believe, to preempt, I know the questions that will come, that a mandatory minimum penalty is warranted in these instances, both for general and specific deterrence and denunciation of this type of offence involving service animals. And like members of the military, members of the police, some of whom are members of this committee, these are service animals that are in harm's way, is the only way I can describe it. They are doing a duty that is a higher calling expected of an animal, the same way that police officers, of course, assume a certain degree of danger and liability. And so, with respect to the mandatory minimum penalties imposed by this bill, I would ask the committee to take note that this provision was carefully tailored in several ways. First, the prospect of the mandatory minimum penalty being imposed only arises in regard to the intentional killing of the law enforcement animal while aiding a law enforcement officer in carrying out those duties. And secondly, the potential application of the mandatory minimum is further limited by the fact that it would only apply where the Crown Prosecutor proceeds by way of indictment. So prosecutorial discretion is always exercised with a careful eye to proportionality, constitutionality, and totality, the same considerations used by a judge. Where the Crown elects to prosecute this offence as a summary conviction, the mandatory minimum penalties obviously don't apply. And finally, in terms of the length of the mandatory term of imprisonment, the 6-month term of imprisonment is at the lower end of the range. I would pause here to underscore, as I mentioned earlier, that the judge who sentenced Quanto's killer specifically imposed an 18-month sentence of the 26 months that was handed down for the killing of that service animal. Bill C-35 also proposes to amend the criminal code to require that a sentence imposed for an assault on a police officer or certain other peace officers will be served consecutively with other sentences imposed with the offender arising out of the same set of circumstances. Nous créons fermement qu'une attaque contre ces agents.
We are strongly of the view that attacks on these officials who work on our behalf to protect society also represent an attack on our society, and that such a provision is justified to express society's denunciation of such conduct and as a general deterrent.
Mr. Chair, I would be pleased to answer your questions and members of the committee with regard to this important bill. I again thank you for the work of this committee, and I take the opportunity to thank all those members of police, military, and those who use service animals for things such as comfort and the mental health counseling that we are now seeing through canine and equine counseling, which are also an extraordinary use of animals in society for the furtherment of the principles of justice. We had a recent example of a dog in the Edmonton Police Service who testified with a child who was obviously feeling the trauma of a sexual assault, and that dog was allowed to be on the stand with that young girl while she gave her testimony. And I think this is the type of innovation that is actually brings great credit to our justice system, and it shows and highlights some of the great people that we have working alongside those animals to further the interests of justice. Thank you, Chair.
Okay. Thank you, Minister. Thank you for those open remarks. We will now go to the question and answer period. The first question from the New Democratic Party is Madame Boivin.
Merci, Monsieur le Président. Merci, Monsieur le Ministre.
Thank you, Mr. Chair, and thank you, Mr. Minister, for being here to discuss Bill C-35. Indeed, I do have some questions for you. Some basic questions. Bill C-35 applies to a certain reality which is part of our jurisprudential landscape. This was passed in second reading before being sent here to committee. I'm referring to the Supreme Court decision which was made not long ago, which partially answered that indicated the question of sending issues before the court dealing with mandatory minimum sentences. Even though I don't necessarily disagree with the comment that you made in the National Post, I didn't read that this was a complete approval of mandatory minimum sentences, but I agree that it is not a decision that says that it is illegal to have mandatory minimum sentences. But I'm less of a cheerleader than you are when it comes to the decision in this context. That being said, I would like to deal directly with Bill C-35. Since the Supreme Court decision, have you briefed your officials from the Department of Justice to determine the effect of the Leonard decision will have, especially when it comes to mandatory minimum sentences and the two tests that must be passed? Have you had this analysis made by officials at Justice Canada, and if so, what was the response? And how do we respond to the Supreme Court sense in relation to the decision made by the Supreme Court with regards to mandatory minimum sentences, with regards to that it's a hybrid, we can't leave it to the discretion of the Crown. How can we pass the two-level test to ensure that it's not a cruel and unusual punishment on the one hand, and if it is not, to move on to the second test? Would there be, for example, as the Supreme Court Justice said, we have to ask if this is a reasonable application of this measure and if this will involve creating cruel and unusual punishments. Have you been able to answer those two questions through your officials?
President.
Thank you, Mr. Chair, and thank you to my dear colleague for this important question. This is not a theoretical question. This is a question that's important for everyone and for every bill that we've presented to this Parliament.
The Nur case, as my friend has said, we look at obviously the entire decision of the court, including the dissenting opinion, but what came from that decision, as she's alluded to, is that mandatory minimum penalties were in no way ruled out as an option for criminal code sanctions. They were, however, limited in the specific case based on the facts before the court that dealt with penalties around firearms. Now, I would suggest that some of the interesting dictum that came from that case also talked about the importance of not stretching the credulity. That is to say that the reasonable hypotheticals were viewed by some of the judges as not being, quite frankly, reasonable, according to some of those.
They're descending. So
Those were dissenting
I hope
opinions.
our Minister of Justice still believes that a majority of the court has ruled, and then that is the rule of the land on the issue. I mean, we can prefer the dissension all we want, but the rule of law right now stands with the majority. So I'm being specific. I want some arguments. I want you to convince me that based on the decision, on the NER decision, that C-35 would be okay with the decision, the NER decision. That's what I'm asking. And if you ask your officials to review the legislation after the NER decision.
Well, let me answer you specifically. Yes, of course. Officials at the Department of Justice always review these decisions. I review them. We look specifically at the entire decision and how that impacts on existing legislation, on future legislation, and including this bill, which is before us. And so to come back to this issue of the test of the cruel and unusual punishment and the gross disproportionality, I believe, our officials believe on balance, that based on the decision in the case involving Qantos that I referred to in my opening, where the judge in that case actually handed down a sentence that was 4 times more than what we're discussing here as a mandatory minimum. So for that reason, I believe in some ways we already have jurisprudence to look at as a touchstone as to both of those questions, both proportionality, taken in concert with other sentences that occurred at the same time, and with respect to the issue of cruel and unusual punishment. I would suggest again that that is very instructive when we go through that test and that analysis. So the constitutionality, I believe, is sound. Yep. and would support upholding this particular sentence. You
also touched on the point of the way of the wording of C-35, in a sense that by saying without a reasonable excuse, doesn't that add to the argument at that point in time that those unforeseen or foreseeable reasonable cases that could rise up or arise from a specific situation then would be corrected by the fact that it wouldn't fall in C-35? And also, why have excluded from the minimum mandatory minimum sentence the other type of animals that are included in the infraction? I'm still, are you making different class of dogs and horses?
Yeah, quite frankly, we are. We believe that in circumstances involving police animals, and this may be a question best posed to those who are using police animals and will be appearing before this committee, but my understanding is that the rationale for that is the degree of harm and the degree of exposure that animals would have in those instances that would, again, justify or bring about a commensurate higher sentence. Coming back to the question with regard to why we have proceeded with this hybrid type of offense, again, we believe that there are facts and factual circumstances that very often arise that would justify a prosecutor in conjunction with the police deciding to proceed by way of indictment. So that obviously involves more egregious circumstances where there was a deliberate attempt to kill or injure the animal, as opposed to a circumstance that one could envision where the animal, while in pursuit of a person or during a search and rescue, went after the wrong individual, for example, and the person, in fear of their life, used what they felt was proportionate force to protect themselves, and the animal was injured or killed. So those are circumstances that might result in the laying of a summary conviction offense that would not have these mandatory minimum penalties attached.
Thank you, Minister. Thank you for those questions. Our next questioner from the Conservative Party is Monsieur Gauguin.
Chair, and thank you, Minister, and thank you to the officials for testifying today. And of course, we recognize the importance of this as another element in the protection of Canadian society. We know how animals, service animals, and enforcement animals play an important role in protecting Canadians. And we're wondering exactly how you feel, Mr. Minister, how the legislation will better protect law enforcement animals, service animals, and military animals, and how does Quanto's law improve the existing laws? Could you focus on that, please?
Well, I suspect that the most direct example I could point to coming out of the Quantos case is the profile that is placed, and this legislation will underscore, on the value that these animals bring to their task, to their service, to our country. We included military animals, and I can speak somewhat personally from having observed the use of military animals in Afghanistan, where they provided tremendous service, again, at great risk. They are often used in the detection of explosives, IEDs. They will use them, and many people would have seen them at airports where they're detecting drugs, sometimes contraband material, including weapons. So these animals have, by design, assumed a certain amount of risk, and we want to protect them. I think you will hear very shortly from witnesses the value, the financial value and investment that comes with these service animals based on the training, the time that it takes. Not every animal, obviously, is designed for this type of work. Horses, for example, are also used very often for crowd control. They're used by the Royal Canadian Mounted Police. They're very often used in situations where they, too, can be in harm's way. And so it places these service animals at a higher threshold. It obviously has penalties attached in a way that is designed to deter individuals who might be so inclined to harm them, to injure them, to kill them. And for those reasons, we have encapsulated this in a bill that brings about mandatory penalties and, in some cases, fines, not necessarily mandatory penalties depending on the circumstances. I should also praise Kostas Menegakis, who brought this bill forward as a private member, and it was later incorporated into this bill that you see before us presented by the government.
Thank you. Minister, Madame Boivin focused a lot on the aspect of the mandatory minimum sentences, and we know in R versus Nur that the sentences, mandatory minimum sentences, were found unconstitutional because it was felt that the imposition was grossly, disproportionate to what the gravity of the act it was. Yet they did, in that case, uphold the sentences which were beyond the mandatory minimums. And I note in the case of Quanto's law that the judge actually imposed 18 months. It's my sense that animal lovers and Canadians by and large would certainly be well accepting of a mandatory minimum sentence for the killing of an animal, in enforcement and the execution of its duties. I mean, are you concerned about this law in any way being found anti-constitutional because of its disproportionate quality in relation to sentencing?
Well, thank you, Mr. Gauguin. As I just said in an exchange with Madame Boivin, this is I think, a reflection of society's condemnation of those who would willfully injure animals generally, but when you have animals with specified duties such as these, and the obvious other example that we see and that is encompassed here are those animals that serve the public more broadly. individuals who are suffering from a disability, those who use animals day to day, provide a tremendous societal benefit. And to deliberately target, injure, harm, kill an animal with those responsibilities, we think deserves a commensurate punishment that puts emphasis on the need to protect them. And that is, in fact, what we're doing here, is attempting to put greater protections in place for those animals who are protecting society at large through their service. So I agree with your assessment. I think that Canadians generally would be very much in favor of this. I haven't heard really any rational reasons why this legislation wouldn't be welcomed, other than some discussion around the mandatory minimum penalties. But just to conclude your answer, the court having already handed down a penalty that exceeds the mandatory minimum, even in an extreme circumstance where the dog Quanto was killed, I think provides us a good example that it would in fact be upheld as constitutionally proportionate.
You know, when I think of the law enforcement animals or service animals, and I reflect upon the amount of training that's involved in getting such an animal up to speed to be able to accomplish those important roles. I mean, there's got to be a value to imposing that type of a mandatory minimum sentence just to protect the asset and the investment in these animals who do such a great job for society. Don't you agree, Minister?
I absolutely agree. There is, as you mentioned, a tremendous amount of time and effort and investment involved in the training of these animals. I'm sure, I suspect many of you have seen these animals in the rigorous training that they go through. And to suggest that we wouldn't want to reflect society's value of these animals, I think would be wrong-headed. This is legislation, I believe, that will put greater emphasis and underscore the value that they provide us each and every day. And we expect in the future we are going to see more use of animals for what I was describing earlier as animal therapy. They provide great comfort to soldiers who are suffering from post-traumatic stress. I saw a demonstration recently in Halifax by an organization called Pause for Thought, a retired member of the armed forces named Cousineau, Medrick Cousineau, and to see the impact that these dogs were having on the lives of soldiers, police officers, and bringing them to a better place, a safer place, it's helping with regard to their therapy and treatment. They have not lost a single person to suicide when they've entered into this program, and so there's tremendous value, and I think we're going to see greater emphasis in use of animals in the future.
Okay, thank you. Thank you for those questions and answers. Our next question from the Liberal Party's Mr. Casey.
Thank you, Mr. Chair, and welcome, Mr. Minister. You properly anticipated that we would be a little bit preoccupied with the constitutional aspects, and I appreciate your remarks with respect to the mandatory minimums and the discussion we've had to date on that. I'd like to add another element as we talk about the constitutionality of the bill, and that is the within the new section 445.01, the creation of a defense of lawful excuse. And I raise that with you, Minister, for the discussion or the prospect that has the potential of imposing a reverse onus. And certainly the courts have had something to say in terms of reverse onus provisions infringing Section 11D of the Charter. So we've had a discussion around mandatory minimums. I'm asking you about the existence of this lawful excuse defense and the possibility that it infringes Section 11D. So my question is whether you have sought and obtained legal opinion with respect to the constitutionality of this bill, and in particular the two areas that that I've raised.
Thank you, Mr. Casey. As with all legislation presented to the House of Commons or through the Senate, or in many cases even private members' bills, the Department of Justice routinely examines them for their constitutional compliance. With regard to the specific question of whether we believe as a department, based on that constitutional analysis, that the bill is in fact in compliance, the answer is yes. Do we have specific advice that touches on the subject of the reverse onus? I would say no. while it has been contemplated, this is part of the regular examination of bills that attempts, as a court would, to anticipate certain scenarios, certain factual evidence that would that could and would be presented to a court. The reverse onus provisions here and the charter compliance, we believe, again, on balance, would be found to comply with the charter as written in this legislation. I say that because the reasonable excuse presented here would be based on those factual scenarios of a person attempting essentially to protect themselves, or being of the mistaken belief that the animal was going to use disproportionate force in either tracking them, holding them, or, as is the case in some instances where the police train the animal to bite and hold the individual. If the person, for example, and I'm again doing what the courts often do, hypothesizing, but if the person had a panic attack, or the person themselves had prior experience with an animal, and as a result responded disproportionately, injuring the animal, we think that a court would properly consider that evidence in coming to the conclusion that they did use a reasonable excuse. They didn't have the mental requisite, the mens rea necessary to convict a person for having harmed or killed the animal. All of those circumstances, as in many of these cases, would be based on the factual scenario presented to the court.
Thank you. I've read that the incidence of the killing of a police dog, that has happened 10 times in the last 48 years. But I understand that the scope of this bill is larger than that. So my question for you is around prevalence. I understand that the bill has been motivated by a specific incident in Edmonton, but can you give us a feel for the scope of the problem? Do you have statistics that would indicate how prevalent the crimes are that are sought to be addressed in the bill?
Sure. Well, in short, I don't believe that we have accurate statistics, because much of what we heard in the both the drafting process and the consultation period was anecdotal. So many of the injuries that animals have suffered have often gone unreported. They wouldn't necessarily have resulted in a criminal prosecution, for example. In the case of Quantos, obviously the facts were laid out very clearly before the court. It was well reported. I'm also aware of instances, one in particular, where a police horse was struck by a vehicle deliberately, resulting in catastrophic injury to the horse, and they had to put the horse down. We're also aware of some cases involving a person with a seeing eye dog that was attacked, and of course very often an animal's natural protective instincts will be to protect the person that they're with, and that animal was injured. So in short, Mr. Casey, there are well-documented cases that we're aware of. There are others that have been reported anecdotally. In the final analysis, what we attempt to do is create a higher threshold under the law that will protect these animals, that have that added element of responsibility, that bring about that service component. And that's what is being pulled out and set apart from the animal cruelty laws that already exist. That is the intent. It has been drafted specifically with that purpose in mind.
Okay. Forgive me as I continue to try to find a body of evidence to support some of the decisions within the department. My next question is in the same vein. I know that you indicated that longer sentences will serve to have a general and specific deterrent effect, that was your belief. Is there any evidence that you can point to that indicates that longer sentences do, in fact, have a deterrent effect?
Well, look, this has long been debated in legal circles. I've spent time in a courtroom, as have you. I've taken part in prosecution and defense. My general belief, and the belief of many, I would suggest, is that deterrence, general and specific, is not only used regularly, routinely, every day in a courtroom, but that it does have effect, as does the reporting of it for general deterrence, that individuals who might be similarly inclined, upon hearing that a stiffer penalty, a period of incarceration could result, may impact. Now, how do we measure that to a nicety? It is very much, in many, I would suggest, cases based on how people themselves react and what they say about the impact that that had on them as to whether they were going to commit an offense, whether they were going to bring a gun to a robbery, for example, whether they were going to, after having already been convicted of a similar offense, go out and commit that offense again upon fear of facing a stiffer penalty. So I suspect that you and I, while we may disagree on this subject matter, this isn't going to be resolved anytime soon. We're going to continue to have this debate.
I'm going to resolve it right now. We're moving on. Thank you very much. Thanks for those questions and answers. Our next questioner is Mr. Decker from the Conservative Party.
Thank you, Mr. Chair, and thank you, Minister, for appearing here today. You mentioned in your opening remarks that the animal that was the impetus for this bill, Quanto, was a law enforcement animal. I note that in the bill there's also two other definitions, military animal and service animal, in some cases slightly different penalties with respect to the killing or injury to those animals. I wonder if you could tell us what the rationale was for extending Quanto's law to encompass service animals and military animals as well as law enforcement animals.
Well, the rationale for that, Mr. Decker, and thank you for that question, was to capture that broader category of service animals above and beyond those that are working with law enforcement. This would also involve the type of animals we see working in border services, the type of animals, as you mentioned, that are doing work with the military, but also those animals that each and every day are working and interacting with the general public and are providing a real benefit and a service to not only individuals but to society generally. There was a time, not that many years ago, that it was almost frowned upon for a person to have an animal with them inside, in a mall, in public areas. Now we are seeing the utility that these animals bring, and so ratcheting up, if you will, the threshold of protecting those animals while they're working. And what you'll see when the animals are in training, and this was something, quite frankly, that I needed to remind myself, you're not supposed to approach them. Those who have animals with them while they're working will tell you that. They'll remind you, look, I'm sorry, don't pat this animal. It's working. It's in the process of providing a service. So I mention that only to underscore that these are, in fact, an animal of great social utility. They deserve greater protection. They deserve greater recognition. And, in fact, I'm also hopeful that they will benefit from greater inclusion and understanding of that role that they provide. Part of the criminal sanctions are for the purpose of protection. Part of this exercise, we hope, is to have a greater understanding of how we work with our four-legged friends and what they do of real benefit for our country. We have, not far from where we're gathered here, Mr. Chair, a statue that was built to recognize a dog that gave its life in service of Canada during the war. Picked up a grenade in its mouth and ran away from the soldiers who were gathered in that area, and thus, when the explosion went off, the animal died. The same thing in Newfoundland and Labrador. There was a very famous dog that was the mascot for the Royal Newfoundland Regiment that gave its life in service of the country. And so these are, acts of heroism by our furry little friends that really deserve recognition, and similarly, not to in any way diminish the importance of it, deserve protection under the law.
I know a woman who has a seeing eye guide dog, and not only is this dog absolutely essential to her ability to live a normal life and get around in a very congested city like Toronto, but also there's a real bond between the owner and that animal that's been developed, and it's not something that can be replaced very easily if that animal is destroyed for any reason. I was wondering if you could tell us, were consultations held on the development of Quanto's law, and if so, who was consulted and where were they consulted?
Mr. Decker, to answer that question directly, there wasn't the type of consultations, for example, that might normally occur, but what we saw was consultations and empirical data and information gathered by one of our colleagues in presenting it as a private member's bill, and going back to the speech from the throne commitment. That commitment came about in large part. This bill was drawn from that private member's bill, but there was visits to police training quarters. There was opportunities to hear directly from those who had worked with service animals, both military and police and otherwise. And again, so there was a body of evidence and a body of information gathered by our colleague, Costas, as well as some of the information that we gathered in the course of the speech from the throne commitment.
What kind of reaction have you received from the public in Canada? My late mother was a great believer in the value of animals. She was a dog trainer and showed dogs, and she used to say to me all the time, "There are no bad dogs, only bad people." What kind of reaction are you getting from the general public about this?
Well, I must say, having grown up on a farm and always we always had dogs, and some of my closest friends, in fact, one of the police officers in my hometown is the dog man, as they say, and he's had several animals that he's trained and used in the course of his career. He's given evidence before this committee, Sergeant Dwayne Rutledge. Time and time again, when the subject comes up, which it does on occasion, the public are overwhelmingly in favor and supportive of anything that would protect a service animal. There's I think a tremendous and even growing respect for the service animals, police dogs in particular. You're seeing all sorts of different animals. When you go to the United States, for example, you see giant poodles being used at airports, which is not a dog that you would normally associate with that type of work, but because of their ability to sense, their olfactory senses are very accurate. So different types of animals provide different service. The comfort animals, again, for a reference, some will sleep in the same room with a soldier suffering from post-traumatic stress and wake them up when they're having night terrors. Will provide the type of comfort and companionship that is so very important to somebody who is feeling anxiety. And the dog can actually sense that anxiety where another person might not. That is, again, a gift, I would suggest, and of great value and in need of protection, what those animals do. Okay. You referenced the bond that's formed between persons and animals. It's a very real thing.
Okay. Thank you, Mr. Decker. Thank you for those answers. Our next questioner from the New Democratic Party, Madame Clay.
Merci beaucoup, Monsieur. Thank you, Mr. Chair. I'm very pleased to have the time to ask a few questions of you, Mr. Minister. Thank you very much for appearing before us. My first question, the section dealing with situations that you reviewed during the drafting of this bill, what was the jurisprudence used? Jurisprudence of our law courts, for example, in the case of Quanto's law. The act wasn't in place, of course, when there was a sentence handed down in Edmonton. What kind of sentences did you base this bill on when it came to people who mistreated animals? Thank you for that question. The answer is simply that the case of Quanto is not the only one. There were others. You did refer to various sections of the criminal code.
There was a conviction obtained by the Crown under a different section of the criminal code, and what the sentencing judge did there, I suspect, is look at the fact that this was a police animal as an aggravating circumstance. as opposed to a specific offense, which is what we're talking about here. And so while there isn't a great deal of accumulated case law on this particular subject matter, there is some. Mr. Casey said it's somewhere in the range of 10. We looked at, I think, 12 to 15. There were a few others, perhaps, that didn't show up because they were provincial court cases and perhaps not as prominent. But the Quantos case and the resulting C-35, again, is an attempt to encapsulate the specific role and the specific purpose that these animals play above and beyond an animal that is a pet or an animal that is kept for domestic purposes. We've heard of, and again, one of the more horrific examples of animal abuse is these puppy mills where they raise animals for the sole purpose of mass producing them, and they're abused. Dogfighting is another specific example in the criminal code. So in answer to your question shortly, we didn't have a great deal of case law to depend on. We looked at Quantos, we looked at the circumstances there, we consulted with police and those officials who work directly with animals and determined that this was a value proposition to put a specific law in place to protect those animals.
So you feel like the courts haven't prosecuted enough, or what was about this article that couldn't be applied to a specific circumstances that would be applied by the courts with C-35? What is the difference? What is the difference between the new articles we're going to put, so the new infraction, and the articles like, for instance, 445? What would be the difference? Is it only the minimum sentence that would be considered, or it's other circumstances that weren't included in the section about cruelty against animals?
So yes, it is the mandatory minimum for a higher end type of offense where, based on the facts of the case, it results in a determination that the animal was deliberately killed. There's also the consecutive sentence element. So very often what will happen is an individual involved in assaulting or killing a police officer similarly has done harm to the animal because they work in that team environment. And so that sets it apart from the existing criminal code sections that pertain to animals. They simply don't have that law enforcement component. It's very much akin to, and I hope I'm not going out on a limb here, but it's akin to the recognition under the criminal code of an assault on an individual versus an assault on a police officer in the context of an animal. And so, again, I say for emphasis, we looked at not only this particular offense, we looked at the range of sentences that were applied in cases involving animals that were not service animals, and determined that a higher penalty, including the mandatory minimum and the elevated fine, were reflective of the need to protect those animals and the special role that they play in society because of their work.
Okay.
My next question has to deal with the differences between one of the new sections in Bill 335 and one of the current sections on animal cruelty. There's the issue of legal justification or excuse, because they indicate that the legal excuse is not included in the criminal code. Could you give us examples of a lawful excuse and how that could be implemented in various situations? For example, a protest or a search in an airport at customs, because we're talking about service animals, not just police dogs, but law enforcement in general. What could the excuse be in those cases?
To Mr. Casey's question, similarly, that what's envisioned here is that in every case you're going to look at the individual circumstances that result in the charge, the offense, whether it was an assault on the animal causing harm or whether it was the death of the animal. What's envisioned here is that you have to take into circumstances the condition of the accused and what was in their mind. So that mens rea could be affected by a mental illness. It could be affected by the fear, certainly. certainly. And the previous experience that they might have had as a child, for example, they were bitten, and so they have an elevated fear. Those circumstances would be taken into consideration, both in the attempt by the prosecution to achieve a conviction, but also, I suspect, by a sentencing judge. And so we felt that the lawful excuse, which is available in the criminal code, should apply to this offense. It's not a strict liability offense. And the circumstances there, the examples that I give, very much go to the mens rea, what was in the mind of the accused when they interacted with this animal in a violent way. Did they use what they thought was proportionate force in attempting to protect themselves? If when the dog grabbed them in the arm, they actually grabbed them on the throat, that might justify the individual have to use lethal force to prevent and to save their own life or to save the life of somebody else. So it would be very much predicated on all of those circumstances at the time of the offense that would be examined by a court of competent jurisdiction.
Okay, thank you very much. Thank you for those questions and answers. Our next questioner from the Conservative Party is Mr. Wilkes.
Thanks, Chair. Thanks, Minister, for being here today. And before I start, I just want to say that every few months I go out to Plaque 16 and name number 20, which is Michael Boudet, who was killed on March 19th, 1985, as he took his dog Trooper in to detain Michael Eugene Orris and was shot in the back of the neck. And unfortunately isn't with us anymore, but he is probably the epitome of what a dog handler is there. They are first in and last out. And you had mentioned earlier, Minister, about law enforcement animals and what they're used for, but I wonder if you could maybe take us down the road a little bit about the training that they undergo and where that takes place from the perspective of the RCMP anyways, and anything else you might want to add to that.
Thank you very much, Mr. Wilkes, and as I've done on other occasions, I know other witnesses have. Thank you for your service in uniform, and your experience, I think, is very important and instructive on a number of these cases. You referenced the training regime that these animals go through. What I have seen both in the police training of animals, military training, and they're often contract employees, is that it's extremely demanding, rigorous. These animals are selected the same way that Olympic athletes might be selected. And again, I don't think that's a stretch because many of these animals just don't make the cut. They don't have the physical prowess. We have an Olympian here, Kyle Seaback can speak to that as well. But I truly believe that goes back to the question of the value that we place on these animals, the investment. Some of these animals, when you calculate that training regime, the investment of time and effort put in by individuals with expertise in the area, you're talking about a value of tens of thousands of dollars. These are not show animals. These are work animals. These are specimens who are known for their strength, their endurance, their ability to respond to commands. And every dog, as you know and you alluded to, forms a very special bond with their handler. There is that very special, again, esprit de corps that exists in dog handling units. They are ready to die for one another. And they are very often in circumstances where that possibility exists. So I come back to the very, I think, important point that these are animals deserving of the type of protection afforded to them by placing greater emphasis on deterring individuals and anyone who would deliberately harm an animal in the provision of that service.
I can say, Minister, I've been on the practice end of a service dog several times, and you want to ensure that you lead with the arm, because if you don't, things don't turn out well. So one part of the bill I did want to, and I don't know if you're the one to ask or the staff that you have with you, and that is with regards to under the definition section. Under law enforcement animal, it means a dog or a horse. But then when we go to military animal or service animal, it only says means an animal. I wonder if there was a reason under this bill why that was termed that way.
The simple answer is that for the purposes of law enforcement, at least in this country, although there are some examples that I could give from other jurisdictions we looked at, it is limited to dog and horse. Those are really the only animals that have been used in Canada for law enforcement in our history. Military animal and service animal could conceivably involve a broader definition. One that comes to mind that has not been used for decades was carrier pigeons. But that, again, is probably not a very good modern example. We have seen the use of primates in other jurisdictions for the purposes of military. And some individuals, again, persons with disabilities, may find innovative ways in which animals are able to help them in the daily conduct of their lives. But the classic examples that we have seen for border services, for police, for military, are dogs that are used for protection, for searches, whether it be narcotics or other illicit substances, VIP protection, crowd control is another one, and the avalanche and search and rescue dogs in the context of the tragic circumstances we're seeing unfolding in Nepal. We know that animals provide invaluable service in their ability to respond to avalanches, what we're seeing in the Himalayas. So that was the reason we tried to sort of constrain the example in the police context, law enforcement context, to animals being dogs and horses.
Thank you very much.
Okay, thank you, Minister, for your time today on kicking us off on C-35. Just members should know that I'm unfortunately due somewhere at 4:30. You may have noticed the Japanese delegation that was here for a bit. I thank the Minister for meeting with them briefly after question period. Actually, the head of their delegation used to be their Minister of Justice, so it was an interesting opportunity to meet with them. I'm going to go and talk to them about budgeting and estimates, Madame Paquet, which I love. So I'm off to that. So I'm going to we're going to suspend. We'll turn the second half of the meeting over to the Vice Chair, Madame Boivin, and with 4 officials. But thank you very much. Just so you know, on Wednesday we have 4 witnesses. We've got the 2 hours set aside for the 4 witnesses. If we use the 2 hours, great. If not, but that's what we have that has been provided. Okay. With that, I'll suspend.
We are going to restart.
And passing that great hour answering all the brilliant questions you will receive. Thank you, Mr. Zegeyer and Ms. Morancy. So do you have any opening comments to make? I thought so. So we'll start the round of questioning with Madame Peclet.
Bonjour.
Well, hello. Listen, during the first hour, the minister answered questions with regards to mandatory minimum sentences, but I'm sure that you were expecting us to ask the same question of you. In the department, did you review the bill pursuant to the Supreme Court's decision, the NER decision, when it comes to the use of mandatory minimum sentences in Bill C-35? In the sense that does it conform to the Supreme Court's decision? I believe that the minister answered your question very well. Of course, we did look at the recent decision made by the Supreme Court in this matter, in this legal matter. To summarize, we think that the bill will not be perceived as imposing a cruel and unusual punishment. It will not be perceived as such, given that even if we look at the decision made in Quanto's case, the minister referred to that decision. The court imposed a sentence of 26 months for several offenses, and the judge indicated that 18 months of that sentence were attributed only for killing that animal. We can speculate that if there had not been any other offenses, the judge could have given more than 18 months for having killed that animal. It is possible to speculate in this case. When it comes to cruel and unusual, it's not excessive to say that there should be a 6-month minimum compared to what the court already sentenced in a similar case because of a different offense, a sentence imposed under a different offense.
Là, nous avons essayé de penser à d'autres.
When it comes to the reasonable hypothetical, we concluded that in this aspect, the bill could withstand the test.
Would survive a constitutional challenge.
Et justement, est-ce que dans vos consultations,
in your consultations and in your reading of available jurisprudence, I know that my honorable colleague, Mr. Casey, raised the issue that there were about 10 cases that we had seen over a certain period of time. What were the sections or the cases? And if we just look at animal cruelty and not any other offenses for which a person stood accused, but what were the criminal offenses that were used the most often in these types of situations, which is to say in the cases that you looked at? And what were the sentences? We were talking about Quanto, but there are other cases. Thank you for your question. The only offense that exists in the criminal code that could have been used to prosecute someone that kills a law enforcement animal would be Section 445.1, cruelty to animals. And, indeed, that is the section that was applied to prosecute Quanto's case. That's about all we can say on that. when it comes to jurisprudence. It does not allow us to conduct an analysis of previous cases because we don't specify the nature of the animal that was killed or injured under Section 445.1. That's fine. Talking about 445.1, the big difference has to do with the lawful excuse. 445.1 indicates that it's if someone were to voluntarily or willfully kill or maim, and it has to do with the... So the language is somewhat different. I would like to know if, in your consultations, when you decided to use this particular language, a legal excuse or reasonable excuse, what were the cases that were presented to you, or what made you decide to use that particular term? I think the best thing that I can do to try and find a reference, which the Library of Parliament provided in its analysis of this bill, Section 429.2. This section indicates that no person shall be convicted of an offense under Sections 430 to 446 where he proves so that he acted with legal justification or excuse and with color of right.
Of an offense under Sections 430 to 446, where he proves that he acted with legal justification or excuse and with color of right. Ce projet de loi, cette nouvelle infraction tombe à...
And under the bill, this new offense falls under those sections. Therefore, this defense applies to the new offense. You have no time left. We're moving on to the Conservative side. Mr. Cockin.
Madam Chair, I want to thank the officials for remaining behind here, and just if you'll indulge me for a minute, I'd like to get on the record some of the things that the Minister brought up when he was here. When he brought up the animals that were used to treat soldiers with PTSD, I thought it was very, very appropriate given the timing. In my writing, I'm very lucky to have Can Praxis, which is an organization that uses horses in doing so. And just like dogs, you can't fool a horse when you're having relational issues or other kinds of stressors in your life. If you ride a horse, and I spend a lot of time on horseback, if you spend a lot of time with a horse can tell when things are right, and it can tell you when things aren't going well. So I certainly appreciate the value that service animals do have, whether it's in service to our veterans or in service to our law enforcement personnel. For a little while in my career, I was the ranger in charge of Red Lodge Provincial Park in Alberta, which is directly west of the RCMP dog training facility, which is south of Innisfail, between Innisfail and Bowden. And I spent many a day there, especially on the weekend, the weekdays in between, particularly in May and June when there wasn't a lot of campers at the provincial park. The RCMP staff would come out there with their training dogs and use that park and that facility as part of their training grounds for those canine units. And like Mr. Wilkes, I made darn sure that when I was out there I had the right equipment on my arm and made sure I led with that when the dog was coming. I also had similar experiences when I worked as a national park warden in Jasper National Park, and we used dogs to detect potential poaching and various other kinds of potential offenses that wouldn't otherwise be easily detected by human beings. So I guess my question to the officials here is, when you take a look at the bill is very straightforward, but it doesn't give us a whole lot of insight into insofar as the people who might be watching or going over this debate. Especially when it comes to Canada Border Services agencies, I think everybody who uses an airport or has gone to a border crossing understands and sometimes sees dogs that are there. Can you tell us something about what these service animals, what these dogs have been able to do to help prevent contraband from coming into Canada?
I suppose I'll start with the Canada Border Services animals. We've seen them at the airports. We see them sometimes on television as they're walking past passengers and past baggage. And I can tell you that there's the Canada Border Services Agency has a detector dog service. And as I understand it, there are about 53 detector dog service teams. So that would be the operator and the animal. And they serve to facilitate and expedite the inspection of goods coming into the country. Because you can imagine it might be a lot more labor intensive if you didn't have them screening and using their God-given gift of being able to sniff. Although they are trained, it does take specific training for them to be able to detect explosives or certain types of drugs. With regards to police dogs, in that case, and now I'll make mostly a reference to the RCMP, they have what we understand is 157 dog teams across the country. And as the minister was saying, they are involved in all types of activities, including VIP protection, crowd control, and as you mentioned, horses are used in that connection as well. And if I can just step away and talk about horses a moment, because we've been concentrating on dogs. Mounted officers, when they're in a crowd or there's a crowd situation, suppose someone in that crowd, it's Canada Day, it's not even a demonstration against something, it's a happy occasion, but someone has a heart attack. Well, if there's a mounted officer, the people on the ground can see the officer. He's higher up, he's more visible. And it's also, in the reverse situation, a mounted officer can see perhaps something happening. So they really are a team, and they really are useful in law enforcement. And what distinguishes these animals from all the other animals is that important role that they play in the administration of justice and in assisting the police not only to enforce the law but also in helping people to obtain medical treatment or whatever.
Well, I appreciate that. Like I say, as somebody who has spent a lot of time on horseback, and that was my job when I was a National Park Warden, actually. I was a backcountry warden. I spent hours on that horse, and I still do so in my own spare time when I go hunting or camping in the Rocky Mountains. I'm lucky to be from Alberta and have those opportunities, and I understand the bond that's created between a master, if you want to call it that, and the service animal, whether it's a horse for the very reasons that you highlighted, or for a dog, with a dog for the very same reasons that you highlighted. There has been a lot of questions and concerns brought up about some of the issues around mandatory minimum sentences and some of the other provisions that we have here. But one of the questions that I have a bit of a technical concern with, and I'm while I agree totally in principle with the legislation, I guess from a technical perspective, we've seen animals being used in space exploration. We've seen animals being used in a lot of different capacities, where some of the reasons might be for the ability of the animal, but the other reason might be simply because the animal is being used because we want to remove a human being from that initial point of contact, or there is a safety consideration or a safety concern. And I think that there is two folds to this when we're dealing with, especially when it comes to service dogs. One, they can provide the services that more quickly and efficiently and more accurately, like you rightly said. But they're also sometimes sent into situations where it might not be presumably safe for an officer to go in initially, or it simply might be too cumbersome. I mean, a foot race between two human beings takes a lot longer to resolve than a foot race between a German Shepherd and a human being, for example. And I'm just wondering, when we put these provisions in place, and I'm sure these provisions will be passed, they will confer onto these animals a certain level of protection above and beyond other animals, and rightly so, for the risk and so on that they are taking undergoing these particular activities. I'm just wondering, are there other jurisdictions that we are aware of when it comes to other countries, or is there other jurisdictions within Canada already at the provincial level that also have certain protections offered to service animals?
Well, Mr. Calkins, you took your time and his time to answer, but I'll give you 30 seconds to answer. I'm so glad to say this to somebody.
Yes, other jurisdictions have specific laws to, similar to what is proposed in C-35, to create a specific offense for the killing or the injuring of a law enforcement animal, and even in some cases with regards to service animals.
Monsieur Casey.
Thank you, Madam Chair. Mr. Segayer? Is that close?
It's perfect.
Thank you. I want to continue the conversation that you started with Ms. Piclet with regards to Section 429(2) of the Code. And you pointed out that Section 429 sub 2 provides a defense. And the new section also provides a defense. So my question is how the two fit together. So if we look at what's in the code now, 429(2), it provides a defense where the accused proves that he acted with legal justification or excuse and with color of right. And this act amends the code to insert the words willfully and without lawful excuse. So my question is this. The new words that we are adding into the code, do they broaden, limit, or simply repeat the legal defense in law that exists?
I think that the best way to answer that is to say that the courts, if ever this provision comes up under a prosecution, the court will consider, or the accused will advance whatever defense he believes or she believes she can to the charge. The key elements, as the Minister was saying, is the willfulness, the intent to commit the offense. The defense of without lawful excuse, it's essentially the reference to 429(2) is to indicate that it's not new law. That requirement or that ability for the accused to demonstrate that he had some lawful excuse for doing the act has been with us for some time. I was trying to think of an example where this might be applicable in conjunction with an assault on a law enforcement animal, and I came up with one which it may or may not be a reasonable hypothetical, but I'll leave it with you. If one had a situation where a law enforcement animal was used more like a weapon by the police officer in an inappropriate fashion to attack an individual. And let's add to that the fact that it was not a lawful arrest that was being attempted, then I would think that that person would have the ability to defend himself, at self-defense, against this animal, against this assault that was being perpetrated with the animal, and as such, that would be a reasonable excuse that one would bring at the trial if he was actually charged with having wounded or injured the law enforcement animal.
I guess my question is whether the words that are being added into the code add anything, given the existence of 429(2) now. So in the example that you just gave, presumably 429(2) would provide a complete defense for the accused in those circumstances.
There might be other provisions in the code that one could rely on, 43 perhaps of the code. In any event, they're consistent. I wouldn't say that they're inconsistent.
Okay. So if they're if there, I guess my question is, why do we need them? Or let me frame it another way. I presume that I'm speaking here to these two witnesses who were either the principal drafters of the bill or the experts within the department of the bill. What was the legislative intent? What was the intent in adding those words, given the existence of 429? And I'm sorry if I'm repeating myself, but was the intention to make the defense of lawful excuse tighter or broader? Have any intent in terms of the defense that already exists?
I guess just to say that there wasn't any specific intent to derogate from 429. Perhaps one could say that one would look at the new provision and the focus of the legal discussion, of the legal argument, whether that it was a defense or not, would be found there rather than having reference to 429.
And I don't have the... Oh, sorry, Ms. Morency, you want to add to that?
I was just going to add that Bill C-35 is proposing a very specific, narrow set of amendments to address a very specific type of issue. The comment that I think you're raising has maybe more to do with the whole area of the provisions, because C-35 is just maintaining a similar approach that's there right now. The reference to 429 sub 2 applies to all of those other provisions, whereas C-35 is only going in to do something very narrow. Perhaps the issue that you're raising is, why do you have it in both places? Well, it's in both places right now with the existing section 445 and 429, and C-35 is just maintaining the same approach. There's no inconsistent or enlarging of the approach taken here.
Well, if it doesn't enlarge it and doesn't limit it, why is it there? Why can't we just rely back to the words that are already in it? That's why I assume by putting those words in there they meant something.
But the inconsistency that I think, or what you're raising is an issue that's there right now in the criminal code. So the approach that C-35 takes is to really model the existing offense, but to carve it out specifically for these particular animals. So the issue is, I think is a more fundamental with all of the provisions there, but it's there now in the criminal code between section 429 and the other animal cruelty provisions.
That's time. Sorry about that.
Thank you.
I have no more names on your side. Then I'll take the liberty of asking you a few questions. Just pour ma clarification.
Just so that I can understand better, the new section 445.011 talks about an offense that is committed willfully without a lawful excuse when somebody willfully kills, maims, wounds, poisons, or injures when they're assisting a law enforcement officer in the exercise of his or her duty. Is the recognition that this is a police animal, for example, is that necessary, or just the fact that it is a dog accompanying a police officer? I'm thinking of protests, for example, where sometimes there are police officers who are not necessarily in uniform. The fact that they know that someone is accompanied by a police dog is essential to the offense or not?
If I understand the question properly, the question is, if I happen to see a dog accompanying a law enforcement officer and I assault that animal, do I fall within the scope of this legislation? The legislation is very specific. It speaks of a law enforcement animal and defines what a law enforcement animal is. And it is an animal that is specifically trained to assist a law enforcement officer and is actually engaged in assisting that law enforcement officer at the time that it is assaulted or killed.
The question was more about, I don't know it's a policeman,
You don't know it's a policeman?
No, I do not know. The policeman doesn't identify itself. Do we need to know that it's a policeman and there's a dog, and we should assume that it is a assisting police animal?
I think that you're getting into the area of legitimate defense or legitimate excuse, because one would expect even an undercover officer to identify himself as a peace officer, as a law enforcement officer, at the time that he's interacting with a private citizen. And if I happen to say, stop, police, and and I happen to be accompanied by this dog, there's a certain knowledge that's communicated by the fact that the police officer says, stop, police.
So it goes into the general defense possibility. You
Yes.
see it as a possible
Yes.
fact that could be raised by the defense on that factor. That's all I wanted to know, if it was an automatic and the excuse had to be outside the actual attribution of the policeman or the dog himself, or...
Well, there's a close connection, and in some instances, the dogs are wearing a kind of a vest. Think of the customs. Sometimes they wear a little, I would call it a vest, that says customs on the side and maybe a flag. And that identifies them when they're walking through the airport, and there's a handler with them, and that handler is always in a uniform.
Okay.
So if you attack that dog as it was working with the handler at the airport, then there's an inference that would be drawn that you knew the type of animal that you were attacking.
Est-ce qu'un agent de service correctionnel provincial...
Can a provincial corrections officer be included by this? Yes. Yes, it's clear.
Law enforcement officer, and that term is specifically defined for the purposes of this legislation. If I can find it, yes. Means a police officer, police constable, or any person referred to in paragraphs, and there's a series of paragraphs from Section 2 of the Criminal Code, but just to go through them, the correctional service officer, an integrated cross-border maritime law enforcement officer or shipwrighter, a CBSA customs officer, a CBSA immigration officer, a fisheries officer, and the military police. But before I hang up on this particular question, I do want to just
Sure.
don't want to mislead. So I'll just take a quick look at the Code criminel.
Let's take a fast look at the criminal code.
Dans le paragraphe B,
In paragraph B, a corrections officer designated as a peace officer pursuant to Section 1 of the Act, of the Corrections Act, Corrections and Conditional Release Act, as well as anyone as a guard or warden or jailer, and any other official or employee of a prison which is not a penitentiary as per Section 1 of the Corrections and Conditional Release Act. Therefore, it would probably be included with that. My last question for you is the one that I asked of the Minister. I know that there's not a large number of cases that are going to be affected by C-35. Its impact is relatively limited. Therefore, I have a bit of difficulty in understanding the logic of excluding certain types of animals. We give them a coverage, but when it comes to mandatory minimum sentences, we say that if it's a police dog, that's more important than horses that accompany people to war or something like that. I'm having a hard time understanding that logic, why a distinction was made. And the fact that people protest animal cruelty, it doesn't mean that we don't like hunters. We've heard all kinds of protests about this when it came to during second reading. In my opinion, the three categories that are covered by this bill, I'm trying to understand. Because for some people, a dog that accompanies someone who is blind is just as important, and it is very serious when if they are killed. I understand that police dogs are in danger, that they're more likely to be in danger. I'm trying to understand the department's logic when it drafted this bill.
All other animals is that an attack on that animal is an attack or an porte atteinte à l'administration de la justice, and that
This is something that affects the administration of justice.
a factor that distinguishes the law enforcement animal from all other animals. Just as there's a reason that we distinguish assault on a police officer in particular, from assaults on ordinary individuals, and perhaps this is an opportunity to refer to the first article, first section of this bill, which specifically creates a new sentencing provision with regards to assaults that are committed on peace officers, assaults, the common assault, the assault causing bodily harm, or the aggravated assault on peace officer. Henceforward, when this legislation comes into force, that sentence will be served consecutively to whatever other sentence the individual is convicted of, so that if the police officer is arresting someone for a break and enter, and that individual resists and assaults the police officer, well, he'll get the offender will get whatever sentence he was going to get for the break and enter, and the term of imprisonment that's imposed for the assault on the police officer will not be served concurrently, but will be served consecutively. And this is this again recognizes that assaults on peace officers, police officers, and these law enforcement animals are actually assaults on the administration of justice, or crimes committed in the larger sense against the administration of justice.
Thank you so much. Anybody else? Questions? Mr. Wilkes?
Thank you, Chair. I just wanted to go back to something that the Chair had just alluded to, and that was with regards to police officers in plain clothes. And maybe just clarify a little bit, having dealt with a fair amount of dog handlers. They are in plain clothes, but they are with the RCMP, they're normally in a blue uniform, not with the yellow stripe. And they, 9 times out of 10, are accompanied by a police officer, by a uniformed police officer. The one exception will be is when they get separated from the police officer in a pursuit of an assailant. But even at that, before releasing the dog, they must identify themselves as a police officer, and they must also say, if you do not stop, if you do not surrender, I will release the dog. Just to give clarification to that. And if I may turn the rest of my time over to my colleague, Mr. Colvin.
Thank you, Mr. Wilkes. I appreciate that. I appreciate that clarification as well. My question, Mr. Ziegler, from the is just a clarification. You went through the clause in the legislation that that is inclusive in the definitions of peace officer, just for greater certainty. And I'll have to go back into the annals of my mind. But years and years ago, when I was employed as a National Park Warden and as a conservation officer for the province of Alberta, I believe I was captured in the definition of a peace officer. So while the particular subsections that the bill mentions does not actually, it highlights a fisheries officer, it talks about correctional services and cross-border services agents and so on. Could you please reassure this committee that anybody appointed with a peace officer status that would be a dog handler at the provincial jurisdiction level who is charged with being a peace officer and a National Park Warden would be captured by this legislation, because there are dog handlers in the provincial, or sorry, in the National Park Warden Service as well?
I appreciate your question because it is true that when this particular provision was drafted, not every person who falls within the definition of peace officer was included in this new definition of law enforcement officer. And my understanding is that the park wardens obtain their peace officer status not through the criminal code, but through the National Parks Act. Again, I'm going to take a moment just to verify that.
This is the reason for my question. Every statute that does enforce or create a law enforcement agency has its own, of course, legislative framework to do that. There is often a clause in that piece of legislation that says this person is an ex officio member of this particular force, or whatever the case might be, which is why I'm asking for that clarification. If you don't have the answer right now, I would be happy to. I think the committee would be happy to get a specific answer if there's somebody that you need to refer to or confer with on this particular issue. But it is a question to which I do think the committee should have an answer, because if there does need to be a technical amendment to the bill to make sure that something like a park warden service dog should be and is intended to be protected under these provisions, and we need to make an amendment to the legislation to do so, then we need to know that as soon as possible.
Madam Chair, I'd be pleased to make that undertaking, that I will examine that and through the Minister's office get the answer to you, or through the Chair.
Excellent. Hopefully before we start the clause by clause, otherwise we will present some type of amendments, I'm sure. Awesome.
If necessary.
If necessary.
My instinct tells me that it's probably already captured. I just want to be sure. I just want to have that reassurance that that particular law enforcement service would qualify under this legislation. Thank you.
You still have time,
No,
but
I'm
you're
good.
okay?
No, I'm good.
Excellent. Alors, merci beaucoup de votre présence.
And so thank you very much for appearing before us this afternoon. I think that this concludes our agenda for today. That concludes our agenda for the day. Thank you very much, everyone.